start. We've already crossed the 500 participants now. Hello, everyone.
Hello.
Hello.
So we are starting this webinar now. I'm Anushree Rauta. I'm a partner at ANM Global, and I had the media entertainment practice there. On the occasion of the World Intellectual Property Day, we are pleased to do this webinar on moral rights and personality rights. Like you all know, we've come to an era where novel ideas and content creation is decreasing by the day. And we are witnessing a large number of recreated versions, remakes, be it in the music industry or in the film industry. There are a lot of biopics which are being made these days. There are a lot of films which are being made on real life events. And these all involve issues, legal issues, which require some clarity. So our endeavor today would be to address some of these legal issues. We have amongst us as speakers, Senior Counsel Dr. Veerendra Tulzapurkar and IP Counsel Mr. Hiren Kamod. Dr. Tulzapurkar, or Veerendra Bhai as we dearly call him, needs no introduction to the IP fraternity. He is the most renowned IP Senior Counsel in the Bombay High Court. He's considered to be an authority in the intellectual property law space in India. Mr. Hiren Kamod has been a counsel in several intellectual property matters in high courts and tribunals across the country and has several favorable orders to his credit. So just before I pass on the floor to the speakers, the way we structured this webinar today is first Veerendra sir would be sharing his thoughts and educating us on the jurisprudence of moral rights and personality rights in India. This would be followed by a very extremely interesting PowerPoint presentation by Hiren. And we would then be having an interactive session where I'll be raising some questions to the speakers and getting their thoughts on some of the integral issues pertaining to these topics. And we can then have the queries from our attendees. You all can put in your questions in the Q&A section, which would be appearing below your screen. And yeah, we can take it forward from there. So Veerendra sir, I hand it over to you now.
Thank you very much. Welcome everybody. The topic under discussion are the two types of rights, one granted by the copyright law and the other granted by the common law. The one granted by the copyright law are the moral rights, and the one granted by the common law are the personality rights. Let us consider moral rights first. Moral rights are special rights conferred by the copyright law on an author. They are both positive right and negative right. The positive right is to claim authorship of the work, and the negative right is to prevent any distortion, mutilation, modification of the work. If such distortion, mutilation, or modification would be prejudicial to the honor or reputation of the author. Simply stated, it means that an author is entitled to be known as the author of the work, or that he is the author of the work, even in cases where he has ceased to be the author. Ceased to be the owner, because the ownership can be assigned, whereas it cannot be assigned. Ordinarily, the author is the first owner of the copyright, but an author is entitled to assign or transfer his ownership. And despite such transfer, he is entitled to claim that he is the author of the work. As regards the negative right, the author is entitled to prevent his work from being mutilated, distorted, or modified, which would be prejudicial to the honor and reputation of the author. It can therefore be said that these are the two, there is a close connection between the author and his work. Mind well that this is not a copyright conferred by the copyright law. As you know, the copyright in three types of work exists. One, a literary, musical, artistic, and dramatic work. B, cinematograph film, and C, sound recording. The moral rights are in addition to these rights and in respect of each of the type of the aforesaid work in which the copyright is claimed or can be claimed. Historically, different countries gave different types of protection to the authors as far as these additional rights are concerned. An attempt was made to bring some cohesion under the provisions of the Berne Convention. It left to the discretion to the contracting states who are party to the Berne Convention to decide the way in which such protection would be afforded. These provisions were extended by the Brussels and Stockholm Act 1940 and 1967. At present, the moral rights are to be found in Article 6 bis of the Paris Act. There are still divergences in the rights which are granted by different states apart from the aforesaid basic moral rights. For example, the right of an author to select whether his work should be published or not, or even the right to bring some cohesion under the provisions of the Berne Convention. It was left to the discretion of the contracting states who are parties to Berne Convention to decide the way in which such protection would be afforded. And as I said, these were granted by the two acts. There are still divergences in the rights which are granted by different states apart from the aforesaid basic moral rights. For example, the right of an author to select whether his work should be published or not, or the right to prevent excessive criticism. In some countries, right to prevent excessive criticism is protected to be special right, while in other countries it is not so on the ground that such right, if recognized, would impinge upon the right to freedom of expression. In India, the moral rights are recognized in Section 57 of the Copyright Act 1957. Apart from granting aforesaid rights under that section, subsection 2 also prescribes that the right conferred upon an author of a work by subsection 1 may be exercised by legal heirs or representatives. Such is the importance of the moral rights. It is not confined only to the author during his lifetime, but such rights can be claimed by his heirs or legal representatives. It is therefore a moot question as to how long such moral rights can be exercised under the death of the author. The first part of the right is known as the right to paternity, where the second right, that is negative right, is known as the right of integrity. It is clear that copyright, and I am not talking about special rights. I am talking about copyright which does not subsist in the work if the qualification conditions are not met or the term of the copyright has expired. The author has no such special rights or moral rights in respect of such work where copyright doesn't exist. For example, an infringing copy, the author will never have moral rights in respect thereof. However, once a work has come into existence as a copyrighted work, the author and his legal representatives are entitled to claim moral rights. It is also to be noted that these paternity rights and integrity rights apply in relation to substantial part of the work as also in relation to the whole work. As mentioned earlier, some countries include a right against excessive criticism. These additional rights, for example, are available in France. However, under English law, generally, there is reluctance to create liability or criticism. See, for example, the decision of Burkhoff versus Burchill, reported in 1996 for All England Report 1008. The reason for not recognizing excessive criticism as an additional right is the right based on the coveted and supreme right of freedom of expression. It is on the basis of the considerations that the right to prevent excessive criticism is not recognized under the English law. If you want to find out what is the definition of the special right, now that is reflected in Article 27 of the Universal Declaration of Human Rights, which is as follows, and I quote, "Everyone has a right freely to participate in the cultural life of the community, to enjoy the arts and share in scientific advancement and its benefits." And two, everyone has a right to the protection of the moral and material interest resulting from any scientific, literary, or artistic production of which he is the author. unquote. It can loosely be said that while copyright looked after the economic interests or commercial interests, the special rights protected what are called moral rights or moral aspect. Moral rights are akin to the rights conferred by law against defamation, whereas it can be said that the right to prevent defamation is public-centric, whereas moral rights are author-centric. In a defamation case, the reputation of a person aggrieved is considered qua the perception by the public, whereas in the case of moral rights, it is perceived qua the author himself. Now give me an honest answer. I will ask you a question, and I am also going to answer that question. The question is, how many of us during school days in the history book drawn mustaches to the photographs of the Queen of England or Chan Bibi or other warrior queens? I for myself plead guilty. You will be interested in knowing that in fact a case occurred when a drawer or an artist drew another picture of Mona Lisa with mustaches. The contention was that it affected the honor and repute of the original artist Da Vinci. The defense was that in the days of freedom of expression, everyone was entitled to express himself in the way he likes. But the defense was turned down on the ground that such absolute right of freedom of expression is not available. This case is elaborately discussed in an article by Leslie Kim in a book published called New Directions in Copyright Law, Volume 2. It was discussed as to the adaptation of work in the aforesaid manner, the treatment given by derogatory or not. The question, does the defendants placing a moustache on Mona Lisa defame Da Vinci by rendering image aesthetically inferior or improve Da Vinci's reputation by improving image? It was argued by the defendant that even if the court found that the modification of placing a moustache on Mona Lisa was an aesthetic impoverishment of the artwork, it could be argued that the wide modern publicity the impure work gave to Mona Lisa had in fact improved Da Vinci's reputation. But this argument was negative. The next question is about the duration of the moral rights. There has been controversy in international treatment of moral rights. Under Article 6 bis, it was left to the member countries to determine what should be the duration of the rights. The Brussels revision in 1948 clarified that such rights should last for at least the author's lifetime, and to the extent the local legislation permitted, at least until the copyright in the work expired. Stockholm revision, to be found in the Paris Act after revision, has made it obligatory for a post-mortem term of 50 years, except in those countries where there did not provide protection at the time of their ratification or of the convention. The 1988 Act of the United Kingdom provides that the special rights continue to subsist so long as the copyright subsists in the work. The Indian law, however, does not make any such provision. While it can be said that to claim authorship can subsist for a period during the subsistence of the copyright, the moral right to prevent distortion should be in perpetuity. This is my view. There cannot be a time limit for protection and honor of an author. Another interesting aspect of this subject is whether moral rights can be waived. There is no ban against not waiving his moral rights. However, such waiver must be work specific and not a general waiver, which I feel is correct way of looking at it. A waiver must relate to specific work and to works of specified description. Coppinger and Stock James, in their treatise on copyright law, have noted that a waiver may relate to the existence of future work, or it can be conditional or unconditional. They have also noted that if a waiver is made in favor of the owner, such waiver is presumed to extend to his licensees and successors unless the contrary intention is expressed. Now, coming to the topic of the personality rights, I will deal with personality rights. You will be an opportunity of hearing case law under the moral rights from my friend Mr. Hiren Kamod, I have confined myself to the jurisprudential aspect of the two rights. Now, the topic of personality rights, these rights are essentially economic rights for the benefit of the person concerned. If the reputation of a very well-known, say, sports person, he is being exploited without his consent to promote trade and commerce, the law frowns upon such person exploiting such a reputation. For example, without the consent of Sachin Tendulkar, a producer of goods issues an advertisement showing Sachin Tendulkar recommending his product without the consent of Sachin Tendulkar will amount to a violation of the personality rights. Personality rights are enjoyed by famous personalities such as human beings in existence. They are also enjoyed by fictional characters such as James Bond, Tarzan, or even animated characters like Tom and Jerry. This is called character merchandising. When you promote your product with reference to such famous artificial character, what you are in fact doing is exploiting the goodwill and popularity of such character. And unless you obtain permission of the creator, you cannot do that. The copyright owner of such characters start a business of granting licenses to such character in advertising of licenses, the advertisements of which are in respect of licenses, goods or services. To what extent an action against a person unauthorizedly using such character will lie, because in order to permission to use such characters which use is in the nature of a trademark without there being any connection in the course of trade between the licensor and the goods or services in respect of which such characters are used, will result in such a license being not in accordance with law, as it will amount to trafficking on the part of the owner of such character. The right, that is the personality right, is ultimately related to the privacy, which is now considered as a right to life under Article 221 of the Constitution of India. Once such right is related to Article 221, there are ramifications as to what extent such a right can be exploited by person himself, and that is a matter which will require deeper consideration. I once again thank you for giving me an opportunity to present my views on the topic discussed above. Thank you very much.
Thank you, Veerendra, sir. That was extremely informative, and it would help all of us over here in understanding moral rights and personality rights. Hiren, I now hand it over to you with respect to speaking on moral rights and personality rights.
Yes. First of all, hello everybody, and I want to say it is such a pleasure to be here on the World Intellectual Property Day, and to be actually a co-speaker and to be here with Veerendra sir and talking on a subject, or rather a field which is very, very close to my heart, intellectual property rights. I must therefore thank Nidish and ANM and Anushree for organizing this. This is like, in that sense, really a dream coming true for me, because I have always seen Veerendra sir arguing in court. We have looked up to him and we have assisted him in so many matters. In some matters, we have been against each other. But this joy of being a co-speaker with him is unparalleled. And I'm thankful again, Anushree and ANM, for doing this. Today's topic is a very interesting topic, as sir has explained the jurisprudential part of it, of this moral rights and authors' rights and personality rights, because this is not something that we discuss every day. Generally, when we talk about copyright in normal parlance, we talk about cinematograph films, artistic works, or their actual commercial exploitation of film sound recordings. But moral rights or author special rights is one topic which is not really touched upon. And sir has told us the jurisprudential part. I will be taking you through various judgments and how the courts have actually looked at this concept of moral rights, how the courts have interpreted moral rights, how the courts have interpreted even personality rights. I have prepared a presentation through which I will be taking everybody. I will begin my presentation, and as I am going through my presentation, I will explain what was held and what were the principles which were laid down by court insofar as moral rights and insofar as personality rights are concerned. Just a second. Can everybody see my screen? Anushree, you can see my Sir, you can see my screen?
Yes, yes.
Okay. Okay, so to really understand, I am going to start with personality rights first and then move on to moral rights. To start with that, sir, explain personality rights. Really, personality rights, there is no special recognition given in any statute. Personality rights really stem from right of publicity, which really stems from right of privacy. So this personality rights is recognized by court through the right of privacy and right of publicity. We have to begin with the judgment of the constitutional judgment of 2017, wherein right of privacy has been considered as one of the fundamental rights by Supreme Court now. And the Supreme Court in that case stated that it is an implied obligation on the part of Union to respect personality of every citizen and create condition in which every citizen would be left free to find himself, herself for self-fulfillment. This is important because there were various contrary judgments because of which, in fact, this constitutional bench was constituted, because there were certain judgments which spoke whether right of privacy is a fundamental right. There were certain judgments which diluted that proposition. And finally, the law was laid down by this judgment saying right of privacy is a part of our constitutional right. Now, right of privacy, what is this right of privacy? Right of privacy really means the right to let me be. Let me be myself, do not interrupt, do not do anything without my permission. I have a right to maintain privacy. I have a right to be as I am. If I do not want any information of mine, personal right to go in public domain, I have an enforceable right. This basically is this right of privacy. I am going to only touch upon this aspect of right of privacy because it is important in the context of right of publicity. Because as I said, right of our personality right is recognized through right of privacy and right of publicity by the court. In 1995, this was a very famous case of Otto Shankar case, as it is called. This Otto Shankar was a convicted murderer. He was a serial killer. While he was in the jail, he wrote an autobiography. Then he gave it to his wife and told his wife to give it to the lawyer. And the lawyer was then supposed to give it to the publishing house. And the publishing house was going to publish it. When the state and the police department realized that in the autobiography which was written, he has actually given actual instances of some police personnel who were involved, they said this will create a havoc, and under the garb of saying that no, this will actually be infringement of the personality right or privacy right of even those officials who were involved, they imposed something called as prior restraint. Government actually passed an order and they restrained the publishing of this book. Publisher went to the Supreme Court, and this was one of the most interesting judgment because Supreme Court there finally laid down that, listen, petitioners have a right to publish what they allege to be the life story or autobiography of Otto Shankar insofar as it appears from public record. So whatever you get from public records, you can make your autobiography out of it, as so long as your material on the basis of which you are making the movie, it is based on public record. Then there was a lot of hue and cry as to what is public record, whether newspaper, magazine cuttings, journals, whether they are considered as public records. The court also clarified there that public record does not mean newspaper cuttings or some interview which was there in the journal or some magazine cutting. Public record only means that information pertaining to a human being regarding his birth, to whom he is married, what was his education, all this kind of information which can be taken from public documents. Only those records will be public documents, and further said that even court records will be a matter of public document. Apart from that, no newspaper, no other magazine material, nothing can be considered as public document. This is what the court held. This case was important because the court said, as long as you are taking the material from public record, right of privacy is not invaded. But the moment you do something more than that, then there will be an infringement of the right of privacy of that Otto Shankar. And there the court also said that this is not a case where you can issue prior restraint. This is important in the context of privacy, as I said, to understand really what is the right of privacy and what the courts have held regarding it. Bandit Queen and Jayalalitha are very good examples of right of privacy. This Phulan Devi versus Shekhar Gupta. Phulan Devi had actually given a license to Shekhar Kapoor to make a movie on her life story. But when the movie was actually made, she was never shown the actual movie despite her requesting it. When the movie came out, she realized there were certain scenes, there were certain things which were never disclosed by her or which were never told by her to him. The defense which was taken by the defendant was, wait, you have allowed me to make a movie. I have made a movie. There is a license agreement. whatever information other than what you have told me, I have taken it from public domain. I have taken from your own interviews, which you have given to newspaper reports, which you have given to magazines. So whatever information, if I've taken it from public domain, you can't stop me, and therefore my film should be released. The court there held no. Here, because whatever information was given by Phulan Devi to you, that information, yes, you could have made a movie out of it. But just because there were some gruesome scenes which were there in the movie, which were never told by her as to whether that had actually happened, just because you found it somewhere in the magazines or somewhere in the journals, that will really not qualify as public record. And your movie therefore has to be stopped because it exposes or it shows those private elements of the plaintiff which she did not want it to become public. So right of privacy was maintained and that movie was injuncted. Same thing happened in the Jayalalitha's case also. There also, Penguin Bookstores, the defendant therein said, we are writing a book on Jayalalitha only on the basis of all the material which is available in public domain. They went a step further. They said, we have actually interviewed different people and people who are close to Jayalalitha. And from that, we have taken certain instances and those we have now put in the book. So therefore, we have not done anything which is not already in public domain. But the court there said, again, laying down or applying the principles which were laid down by Otto Shankar case, that your notion of public document or your notion of public domain is something, public record is something different. Public record means only those things which were particularly mentioned. As I said, that your birth records, your marriage records, who is your child or who are your children, what is your education, that of course, yes. But other than that, just because you have taken certain interviews of people who were close to her, you would not be able to make movie out of it because probably she is not okay with showing those aspects of her personality or those aspects of her private life to public. Accordingly, an injunction came to be granted. These three judgments basically deal with how the right of privacy has overall evolved, and ultimately, of course, in 2017, as we saw, right of privacy ultimately was declared as a constitutional right. Now, why this right of privacy was important was to explain, because as I said, right of privacy and the right of publicity together is recognized as a personality right. Now, what is a personality right really in that sense? Personality right means that any right to control commercial use or commercial exploitation of my personality or any traits of my personality. So therefore, if a Shah Rukh Khan today if a Shah Rukh Khan has a personality right to his name, to his signature, to his image, voice and likeness, these are the things which have actually the courts have, through various judicial pronouncements, they have tried to analyze what do you mean by personality rights and what is the gamut of personality rights. Name, of course, as I said, if somebody starts using something under the name of Shah Rukh Khan or with a image of Shah Rukh Khan, then of course it is an infringement other than copyright and other rights. It is an infringement of personality rights. Signature, if somebody starts using signature of Shah Rukh Khan, obviously that would amount to infringement of personality rights, apart from the other offenses which it would amount to. Voice. Now, voice is a very interesting concept because there has not been any, so far as my research shows, there has not been any decision or any judicial pronouncement insofar as voice is concerned. However, there was a case where some Gutka company, they used actually Amitabh Bachchan's voice in order to promote their Gutka. And that voice, of course, was done by some voice artist and not by Amitabh Bachchan. Amitabh Bachchan had to actually come forward and issue a public statement, which I have included in my slide somewhere. So the court says name, signature, image, voice, and likeness, any likeness to the personality, these basically are the traits of your persona, which can be commercially exploited. And these are the things, therefore, the court will protect. Here, there is actually one more interesting element, which I will show in one of my slides. In the case of Rajnikant, which we will come to, there the argument of the plaintiff was that defendant is using my name Rajnikant, defendant is using my photographs, and the defendant is also using the manner in which I deliver dialogues. So the manner of delivering dialogues also was pitched to a personality right trait. So mind you, voice is different. Voice, obviously, the court has considered, but manner of delivering dialogue. So I was just thinking out loud that if Hiren Kamod, in my voice, if I say the famous dialogue of Amitabh Bachchan about Rishte mein to hum tumhare baap lagte, I may say it in his manner, but I may not use his voice. I may say it in my voice only. But just because that manner is same, we'll have to see whether the court ultimately will consider that as a part of personality right. Or to give you one more example, there are certain gestures of legendary Devanand. those gestures, the moment those gestures are done, without even uttering, without even saying anything, somebody will be able to make out, acha, you are mimicking basically Devanand or late Rajesh Khanna also. So whether these also, the manner in which they have acted, whether they can be considered as a personality right trait, that will be something interesting in future for us to see. Now, what I have done is, after perusing all the judgments, I have culled out certain principles. So 2 slides, I'm going to only show you the principles, and then I will take you to the judgments which have laid down these principles. Very simple. It is an enforceable right. As I said, right of personality is an enforceable right. Though it is not separately recognized as something, it is enforceable and it is recognized through right to privacy and right to publicity. So number 1, right, it is an enforceable right. Second thing is that personality right is considered as a property. How intellectual property is a property, you can sell the property, assign the property, license the property. Even personality right is recognized as a property which you can license it or which you can assign without any transfer of any other assets or any other property. Right to control, which I said, personality right, what is it broadly? The right to control commercial use of human identity is right to publicity and basically personality right. Most importantly, personality rights are available to only well-known personalities. Personality right vests only on those who have attained the status of celebrity. So therefore, if a normal person who is not well-known at all, if he wants to enforce his personality right, and when I say enforce his personality right, take a case where some defendant starts using a photograph of a layman. There, of course, that layman will have other kind of protection, copyright and other sets of protection which he might use. But for the personality right, what is most important is for the plaintiff to show that defendant has used the face, the name, the photograph of a well-known personality in order to commercially exploit it. So that a person, the moment he sees if a defendant starts using, say, Rajnikant, as you know, as a movie, as we will see, or Gautam Gambhir for a name of a restaurant, moment the person sees, would the person feel, hey, Gautam Gambhir, of course, this Gautam Gambhir is that Gautam Gambhir, and Gautam Gambhir must be endorsing it. The question is whether a layman walking on the road, whether when he looks at it, whether he will think that the personality has endorsed it. So the basic requirement for a layman to think that whether personality has endorsed it, that personality has to be a well-known personality. So therefore, this personality right is available to well-known personalities. Now, what are the tests of infringement which have been laid down by the court? Now, please keep in mind at the same time, passing off, infringement of copyright, these are some rights which are available to you independently. We are only dealing with the personality rights aspect. Test of identification. The celebrity plaintiff must be identifiable from the defendant's authorized use. As I told you, somebody starts using Arun Jaitley, somebody starts using Amitabh Bachchan, name with Amitabh Bachchan photograph. Without anything else, without any other evidence, the moment a lame person looks at the use of the defendant, he must feel, acha, this is endorsed by the plaintiff. The celebrity must be identifiable. Second, no proof of confusion is required. Infringement of right of publicity requires no proof of actual confusion or deception. Of course, if there is this kind of a proof, it will definitely help everybody. It will help the court. It will weigh in plaintiff's favor. But that kind of proof is not required as a matter of principle. Then broader right. The right of publicity extends beyond the traditional limits of false advertising laws, which basically means that, as I said, to prove sometimes that by somebody using my photograph or somebody using my name has disparaged or he has defamed me, there are very high standards which are there. But insofar as personality rights are concerned, if I'm a well-known personality, all that I have to show is he has used it, the defendant has used it without my authorization, and he is commercially exploiting it, and because of which people are likely to believe that his products are endorsed by me. That's it. You don't have to cross any other higher threshold as is done in other cases, since it is a broader right. And violation of right. So what does it mean? When the identity of a famous personality is used in advertising without their permission, the complaint is not that one should not commercialize their identity at all. What is the complaint? The complaint is the right to control when, where, how the identity, it is only with the famous personality. That is what really gives the right, the remedy which is given to a right holder is to decide when they go after any kind of a defendant to tell the court that this is my personality right? I will decide how to use it, how to commercially exploit it. Defendant is doing it without my permission. So these are certain principles which have been ultimately culled up from the court's various judgments and judicial pronouncements that we will see. To begin with, we must understand, before I get into this character merchandise rights, Veerendra sir also explained us what is this character merchandise rights. Just before everybody starts reading the slides, just give me a second. Character merchandise right means what really? A character. It is a fictional character, a Donald Duck. Take a Donald Duck. It's a fictional character which is drawn. Or take Shin-chan, or take that Peppa Pig. I'm giving these examples because I have a daughter who's very young and who watches on TV. So all these things I'm introduced to now with Shin-chan and Peppa Pig. So all these are actually fictional characters. They are drawn. But because of their popularity, they have become something as an independent creature. So today, if there are dolls which are being sold, if there are keychains which are being sold, if phones which are being sold with Peppa Pig behind them, so the merchandise, or basically the character, has gone beyond what it was originally made of, and it has gone into a separate domain where it has its own identity. That basically is something that we called as character merchandise right. Now hold on for a second. Character merchandise right is equivalent, same as personality right. When Amitabh Bachchan uses his personality as Amitabh Bachchan, when Sachin Tendulkar uses his personality, Shah Rukh Khan uses his personality, when they use it, what are they doing? They are actually commercially exploiting various traits of their personality. So character merchandise rights is in respect of these cartoons and basically fictional characters. Personality rights are in respect of actual individuals who are famous personalities. Now there is one more aspect which is an interesting aspect. Take an example of Iron Man. When I say Iron Man, I do not think anybody can think of anybody else than Robert Downey Jr. Why? Because it is etched in our mind now that Iron Man, which is a fictional character, has, because Robert Downey Jr. has done it in a manner that he has done it, now they are so associated with each other that it is difficult for us to remove either the Iron Man from Robert Downey Jr. or Robert Downey Jr. from Iron Man. So these are certain things which we will have to see how they turn out over a period of time as when the cases happen. In 2003, this was a case where the defendant came up with an advertisement and the plaintiff sued them saying that there is an infringement of copyright in the film itself because of that advertisement. That infringement of copyright in cinematograph film is a different aspect. I will not touch that. But insofar as character merchandising is concerned, the Bombay High Court very nicely explained this. This highlighted portion which I have shown, this is very important. The fictional characters are generally drawings in which copyright subsists. Example, cartoon and celebrities are living beings who are otherwise very famous in any particular field. Example, film stars, sportsmen. It is necessary for character merchandising that the characters to be merchandised must have gained some public recognition. That is achieved a form of independent life and public recognition for itself independently of the original product or independently of the area in which it appears. Only then can such character be moved into area of character merchandising. So this was the principle which was laid down by Bombay High Court when it came to character merchandising. And of course, it also made a comment about personalities. This principle was used by the court subsequently while enforcing these personality rights. Look at this case. Plaintiff was Titan Industries. Mr. Amitabh Bachchan and Jaya Bachchan were the ambassadors for Titan Industries. There was a proper agreement where a good amount of money was paid to Bachchans, because of which Bachchans allowed themselves to get photographs, and they assigned their personality rights to Titan, saying that you can exploit commercially our photographs and our name. Some Johnny in Muzaffarnagar, he used the very same photographs instead of Titan, as you can see, Ram Kumar Jewellers. And he started advertising it in Muzaffarnagar, UP, with the same photograph, Amitabh Bachchan's name with Jaya Bachchan, the photograph, only Ram Kumar Jewellers was written. When the plaintiff approached the court there said, this is absolutely wrong because you do not have a right to commercially exploit the personality traits of Mr. Amitabh Bachchan, and because that right was assigned to Titan Industries, plaintiff was Titan Industries who filed the suit by relying upon the agreements. Now, here in the facts of the case, the defendant came forward and defendant said, like we have seen in most of the obvious counterfeit cases, the defense that the defendant takes is, "Nee boss, I didn't do anything. Ye product mera hai hi nahi." That is the defense that we have generally seen in the court they take. Here also the fellow took the same defense, saying that I don't know who has done this. Somebody has used my name, and therefore I have also filed a separate police complaint, but I have not done this. The court anyways went ahead, and the court then passed a very good reasoned order. And I must say one of the fine orders that I have seen, where the court laid down those principles about which I showed, the principles which were culled out. There was one important aspect which the court here said. The court said that identifiability is very important, which means that there are two methods of identification. One is unaided and second is aided. What is unaided identification? This is an example of unaided identification, which means the court does not require any aid of any external evidence to come to a conclusion that the defendant, when he uses Amitabh Bachchan's photograph, he means Amitabh Bachchan and nobody else. Or the intention really is to ride upon the personality rights of Amitabh Bachchan. So no other evidence is required. All that has to be seen is, please look at the photograph, look at how the defendant is using it, the manner in which he is using it, infringement of personality right. The court then said, but always the case may not be like that. For example, in cases of name, if somebody starts using, say, Arun Jaitley, that is a case that I will also show you. But if there was another defendant who was also named Arun Jaitley legitimately, and therefore he had a website called as Arun Jaitley, in that case, it won't be an unaided identification, because he would have then a right to say that, listen, my intention is not to ride upon or show that my services are endorsed by anybody else, because I myself, my name is so and so, and I am therefore using it. In this kind of a scenario, the court said there is something called as aided identification. So what is this aided identification? It means the court will then look at, and the plaintiff will have to then lead evidence to show the number of elements which are there in defendant's use, which point out, okay, yes, this is the plaintiff. So bits and pieces of the defendant's use taken together, if they point out only to the plaintiff, then there is an infringement. And if there is some evidence to show the intention was always there to associate it with plaintiff, then it will be an infringement. So principle which you have to remember is that first cardinal rule for enforcement of personality right is the celebrity must be identifiable. Now, how to do it? As I said, one is unaided, where it is obvious when the Sachin Tendulkar name with Sachin Tendulkar photograph is also used. But in that case, it is unaided. Aided will be, as I said, that there is a possibility that defendant's use is with due cause. There is some reason why he's doing it. The intention is not there. In that case, the court will then look into the evidence that is being filed by both the sides. As I said, this case of Arun Jaitley, this was an important case in a way, because here the plaintiff actually requested defendant number 2, which was Network Solutions. When he realized that arunjaitley.com is available for sale, he said, I am arunjaitley.com, you can't sell it to anybody, transfer it to me. There the defendant number 2 said, okay, you know what, Mr. Arun Jaitley, you wait for deletion of the domain name, or why don't you make a certified offer to purchase? So he apparently tried that also. When a normal domain name cost about $35, when he went to buy his own domain name, with his name, he saw the price which was shown was about $11,000 to $14,000. A suit was then filed on the basis that this is incorrect, of course, on passing off, and also on infringement of violation of the personality rights of Mr. Arun Jaitley. In this case, the case became more interesting because defendant number 2 transferred the domain name to a complete third party. And there then finally injunction was granted, cost was granted, and the court laid down a very interesting observation. The court said the anomalous situation like the present one would continue to arise, wherein names of the popular personalities like Mr. Arun Jaitley is being registered by foreigner who have no concern with the domain name, because this was actually registered by a foreigner in question. Can some individual from Asian country get the domain name registered of a renowned politician in USA? And is it possible to get it registered so easily as registered in the present case? I am sure that no domain registrar will let this happen, nor the government there will be allowed this to be misused. Let us now take the example at the present case. Plaintiff is an Indian citizen. He is well-known senior advocate and politician, Arun Jaitley being the personal name which cannot be associated with anyone. The point being here, the court said, as I said, if this was a case where defendant was a person called as Arun Jaitley, and if he was using it in respect of some genuine services, then the court may have said that, listen, the evidence laid down probably shows that the intention is not really to associate with the plaintiff. But here it was a straightforward case. defendant was some foreign entity to whom it was the domain name Arun Jaitley was assigned. In that case, there was no question of him having any honest intention or saying that I have some legitimate cause or reason to use it. One more important principle which was laid down by the court was, here the court actually said that right to use a personal name is bigger than your right to use a trademark. Now, this is something which was culled out by the court, but if you see really, it is not something which is new to the trademarks law. Section 35 of the trademark law actually provides that if a plaintiff who is a registered proprietor of a trademark, say Hiren Kamod, is registered by some plaintiff in respect of some services, if I, Hiren Kamod, start using the mark Hiren Kamod, if I start using as Hiren Kamod in respect of those services, though he has registration, he will not be able to stop me, because the law gives a defense of personal use for an infringement action. Passing of the defense is not available, but let me not get into all that right now. But here the court reiterated the principle that the right to use the personal name is actually bigger than entitlement to use as a trademark. Bombay High Court, this was again an interesting case where this suit was filed on 2 counts. One was defamation and 2 was violation of my personality right. Defamation because the defendant number 1, Mr. Amrik Singh, also known as Mr. Mika Singh, he had put individually, in his individual capacity, he had put some billboards, hoardings, which were advertising the Radio Mirchi Awards which were going to happen. Now, Radio Mirchi had also put their billboards, but the defendant, as in Mr. Mika Singh, also had put some billboards in which he had shown the photograph of the plaintiff, Mr. Sonu Nigam, and other certain artists. The photographs were shown in a smaller size, and the defendant, Mr. Mika Singh, he had shown his photographs on a bigger size, as if he's bigger in sense of a personality. The plaintiff then rushed to the court saying that on 2 counts that this is defamation, number 1, and number 2, this is violation of my personality right because you have not taken my permission to use my photograph and other traits of my personality. There is no reason or there is no judgment, but ultimately the defendant submitted to a decree. So I'm sure there must have been an argument in the court of law, and ultimately the defendant decided to submit to a decree. And as the trend of Bombay High Court, the Bombay High Court said, all right, you are submitting to a decree, you must pay cost of rupees 10 lakh rupees was paid. And as the practice of Bombay High Court, which was given to a charitable institution. So this was one of the cases where Bombay High Court dealt with in that sense of personality right. This case was, again, now when you look at the right side picture, which belongs to Daler Mehndi, the defendant was found to be selling dolls with the portrait. If you see, it's a caricature in that sense, or a doll which looks like Daler Mehndi. To make matters worse, if you see this portion where I'm moving my mouse, there was actually a photograph of Daler Mehndi. So Daler Mehndi, through his company to whom he had assigned his personality rights, they filed a suit saying that you do not have, amongst other things of infringement of copyright and other infringement, they said this is violation of my personality right. I have not given you any permission. And what are you doing? You are commercially exploiting it in order to make people believe as if this product is endorsed by me. People will feel that I'm endorsing this product or I have given the permission. So the court here said that no, you can't do it. And as I have given the quote, use of Mr. Mehendi's persona for the purpose of capitalizing upon his name by using its conjunction with commercial product is not proper or legitimate. It amounts to a clear dilution of uniqueness of such personality and gives right to a false belief that plaintiff has either licensed or defendants have some connection with them. As I said, that is also one of the most important criteria. Again, as I told you, there were 2 principles. The celebrity has to be identified. That identified can be unaided or aided. This was the case of unaided one, because here no defendant could say I did not know, or this Daler Mehndi means something else, or I did not want to give an impression, because there is a photograph, there is the picture which looks like a photograph of Daler Mehndi and a doll which looks like him. Interestingly, however, the court went a little beyond this, and the court struck a word of caution. The court said a word of caution has to be expressed here. It is correct that we in a free and democratic society where every individual right to free of speech is assured, the overemphasis on a famous person's publicity right or personality right can tend to chill the exercise of such invaluable democratic right. Thus, for instance, caricature, lampooning, parodies and the like, which may tend to highlight some aspect of individuals' personality traits, may not constitute infringement of such individuals' right to publicity. And there the court said the court said, in a way, because freedom of speech and expression, when cartoonists, and they will draw cartoons, as we see, there is a specific element of every personality. When they want to draw our ex-chief minister Veerendra Fadnavis, or if they want to draw Mr. Sharad Pawar, or if they want to draw, in that sense, Sachin Tendulkar, there are some specific elements which the cartoonists, they use their freedom of speech and expression to express. So the court said, not in every case where something like this is done, it will not amount to infringement of or personality right. Now, when everybody, all the famous personalities were busy enforcing their personality rights, here came an interesting case where, for the first time, a corporate entity said, defendant is doing something which amounts to infringement of my personality right. So they actually went, ICC Development International Limited is a company which holds the IP for ICC. The defendant here started an advertising campaign. The defendant was, he was the authorized distributor of Philips. He himself actually spent lakhs of rupees, bought tickets of the World Cup which was going to happen, and then he started selling by writing this, Philips Diwali Manao, World Cup Jao. Buy a Philips audio system, win a ticket to the World Cup. The plaintiff, as a corporate body, sued the defendant. Of course, they also claimed infringement of trademark because the World Cup was used. And then they said passing off because they said he's trying to ride upon our goodwill and reputation. And one of the interesting arguments which was taken here by ICC Development was this use of World Cup and ICC, all this amounts to violation of my exclusive right to monopolize some traits of my company as a personality. There the court said, listen, this concept by a corporate body to enforce a personality right is against the basic concept of persona. Non-living entities are not entitled to protection of personality rights. And this is what the court held. In my considered view, non-living entities are not entitled to protection of publicity rights in an event. An individual may acquire the right of publicity by virtue of his association with an event, sport, movie, etc. However, that right does not inhere in the event in question that made the individual famous, nor in the corporation that has brought about the organization of the event. Any effort to take away the right of publicity from the individuals to the organizers, a non-human entity of the event, would be vocative of Article 19 and 21 of the Constitution of India. No persona can be monopolized. The right of publicity vests in an individual, and he alone is entitled to profit from it. So this was the end of it. Otherwise, we would have seen so many litigations with IPL and then companies saying that the personality right in a specific event. But here the court put a full stop by saying that no, if we do this, this would be vocative of Article 19 and 21, and this is available only to individuals and not to corporate entities. Now, while Delhi High Court and Bombay High Court were busy dealing with all this, there came a very interesting case in Madras High Court. And this is important in the context of the principal people which I told you of identification. The defendant was using this, if you see the name of the movie, called as Main Hoon Rajnikant. So the defendant started advertising this movie. He started putting billboards everywhere. On website, there were interviews and material was placed. When Mr. Shivaji Rao Gaikwad, also known as Rajnikant, when he realized this is happening, he approached the court immediately. Interestingly, because I actually went through the pleadings and I actually went through the pleadings which were done by the plaintiff. It is interesting here because Mr. Shivaji Rao Gaikwad there has taken a stand that as a matter of principle till date, I have never ever given any trait of my personality for any commercial exploitation, because I am of the principle that generally I don't believe in commercially exploiting any trait of my personality. So I have not myself made any movie on myself. I have not written a book on myself. There is no autobiography or a biography. So this is how the plaintiff went. Plaintiff said the defendant is using my name Rajnikant. Plaintiff said defendant is using my photograph, my images. And as I told you earlier, there the plaintiff also said the defendant is also using the manner in which I generally deliver dialogues. And these are all traits of my personality, and therefore the defendant must be injuncted. When the defendant filed his written statement, defendant said two things. Number one, defendant said, there is no such thing as personality right. Personality rights are not recognized in any statute. So therefore, there is no cause of action. That was the first contention. Second contention, the defendant said, in any event, I am using only the name Rajnikant. I am making a statement that I am not using your photographs. I am not using the manner in which you deliver dialogues, nothing of that sort. In fact, there is nothing in my movie which is like a tribute to you or which will associate with you. It is just that Rajnikant is a common name. Rajnikant, there are so many people who have Rajnikant as their name. I have taken the name Rajnikant. My protagonist is called as Rajnikant. Here, this is the first case which as I said, there the court actually then started looking into the evidence, because all the earlier cases which I showed you, there either the defendant didn't come forward or there was no case of looking into the evidence, because the celebrity could be identified without any external evidence. Here then the courts actually started looking into the evidence. When they started looking into the evidence, the plaintiff filed certain documents which showed that the defendants, the director of the movie Main Hoon Rajnikant, had in various interviews actually said, this is my tribute to Rajnikant. And there were various articles which were written by people claiming that, saying that we feel this is a tribute to Rajnikant. Rajnikant, who has not openly exploited his his personality rights, is going to finally come up with a movie. And there were actually people who left, right and center believed that this movie had something to do in that sense with Rajnikant. And there, the directors or the defendants did not really contest it. So that evidence the court looked into. And after going through that evidence, the court said, all right, this may not be a case of unaided identification, but looking at all these documents, I am coming to a conclusion that your intention to use Rajnikant is only to associate or show somehow to the people that Mr. Rajnikant or Mr. Shivaji Rao Gaikwad is endorsing the movie, and accordingly, injunction came to be granted. Incidentally, there was an appeal, and appeal came to be dismissed in this matter. Now, take the same principle. I purposely kept this slide after that slide because there, after looking at the evidence, the court said, no, if I take all the elements of the manner in which the defendant was using Rajnikant, all those elements taken together point to only Rajnikant. So therefore, it amounts to infringement of personality rights. In the case of Gautam Gambhir, defendant said, Gautam Gambhir sued because Gautam Gambhir approached the court by saying, so many people are asking me whether I have started a restaurant or a lounge or a bar by the name, by Gautam Gambhir, because this Havalat lounge and bar by Gautam Gambhir has started in Delhi. There, the defendant filed a plethora of documents, and the defendant said, boss, this is not the first time that I am using I am Gautam Gambhir. My name is Gautam Gambhir. I have 4 restaurants by the name Havalat, ABC, DEA, whatever. And all of them I say by Gautam Gambhir. Then he actually in his evidence, in his reply, with the documentary evidence, he actually put his Facebook pages to show I actually stand next to all these places to show I am Gautam Gambhir. So my intention has never been to trade upon some other Gautam Gambhir because I am Gautam Gambhir. Then he also said, look, there is no element of cricket involved anywhere, either in my advertisement or even when you go to Havalat Lounge and Bar by Gautam Gambhir, on the menu card and all, there is no cricket or some element of cricket to, invoke the memory of this Gautam Gambhir. So on that basis, plus the defendant also said, I'm a registered proprietor, and he was a registered proprietor of Havalat Lounge and Bar by Gautam Gambhir. He said when my mark was published, he never opposed it. On that basis, he said that people will not be able to identify that this is actually by Gautam Gambhir because I have done my very best in order to ensure that I tell people that I am Gautam Gambhir. I am doing this for a long time. There are my 4 restaurants, and you look at the evidence. There the court applied the principle of our Titan case, which I told you about the identification, and the court said that there are no documents. Plaintiff has unable to show with any documentary evidence as to what is the manner. All right, Gautam Gambhir, as I said, there is a legitimate reason because he himself is Gautam Gambhir, so he has a reason to use it. But where do you get it that people will feel that Gautam Gambhir, the cricketer, is endorsing it? Even if you see the elements of the manner in which defendant is using, it does not point to the plaintiff, and on that basis, injunction came to be refused. Appeal was filed, but then that appeal was subsequently not pressed. And then final case, which happened in 2019, when Zee Hindustan was coming up with their news, with their new show, they actually put this advertisement everywhere, where the advertisement said, अर्नब की डिबेट अब कौन सुनेगा, अंजना की जरूरत थी सिर्फ कल तक, इंडिया में अब रजत की अदालत बंद, अब एंकर नहीं, खबरें खुद बोलेंगी, because it was an anchorless program which they wanted to do. surprisingly, the first person who's mentioned did not go to court, who recently went to court. But Rajat Sharma went to court saying that, look, you have used the name Rajat. The manner in which you have used it is without my permission. And this is without my permission. You are commercially exploiting my name in order to promote your program, and this amounts to infringement. The court here said, you are right, because again, the name Rajat, here the defendant could not have argued Rajat means so many Rajat, because Rajat ki adalat is only one adalat. So the manner in which you were using pointed out only to the plaintiff. On that basis, injunction came to be granted. So principle wise, people, these are the principles which I told you. This is what the cases have been for personality rights. As I said, you have to remember privacy rights and publicity rights taken together. The personality rights are recognized through right of privacy and right of publicity. This would have been actually an interesting case had Mr. Bachchan actually approached the court of law. I do not believe that Mr. Bachchan approached any court of law, because I did a thorough research to ensure whether any litigation happened. However, there is a statement which I came across which was made by Mr. Bachchan, where he said when some gutka company started selling, I actually also tried very hard to look for the audio, the actual advertisement, but it is not available, and good that it is not available, because then the purpose of Mr. Amitabh Bachchan in that sense gets served. He issued a statement saying, I was shocked to read a comment from a dear extended family of how a gutka manufacturer was using my imitated voice to flog his product. Now not only is this unethical and wrong, it paints me in bad light as well. This would have been really interesting. Actually, it would have gone to court of law, because as I said, there is a difference according to me in using somebody's voice and the manner in which you speak. So if you consider voice as a separate element, of course, as the courts have said, like in this case, I'm sure the courts would have done it, because the voice would also in that sense include my throws and my punches and the highs and low, which I generally use while speaking. But what happens if I use the manner of speaking, but in my own voice? That would have been some interesting case to see. As I said, till date, there has not been a case like this, but we'll have to ultimately see how the court interprets, if at all there is a case. That brings me to my second topic on personality rights. Veerendra sir has explained to us in detail. These are the cases. I have tried to take as many cases as possible. There were also more cases, but where the principles were repetitive, I have not unnecessarily added them. But the principles which I have told you, those principles are by and large the cardinal rules and principles which the court applies in cases of personality rights. Now, moral rights, as Veerendra sir correctly explained, these moral rights are something, in that sense, really, moral rights have been defined to really be non-economic rights. For example, when I say non-economic rights, let me show you this slide which I have prepared. Rights of author. Under the Copyright Act, an author and an owner, there are two different concepts. Right of author has been, the right of author as the Copyright Act provides has been categorized or can be categorized into two different fields. One is an economic right, which is what? Commercial exploitation of work for economic benefit. Matlab kya? I have written a poem, I have written a song or a lyrics of the song. I give it to a composer, I say, all right, chalo, iska sound recording karo, gana karo, and then, commercially exploit it, give me my royalty. This is commercial exploitation of work, which I'm doing for my economic benefit, which is, so what is copyright has been provided in section 14. That's why I've written provided in section 14, but there are other rights also which a copyright holder has. But predominantly economic rights you can get, that these are the rights which you get: right to sell, right to give a license, right to communicate the work to public, right to make an adaptation, and right to do so many things because of which you will commercially gain. Along with that, rights of author, the authors have also been given a separate right, and I have termed it as non-economic right, which is a special right. Now, what is this special right? Why is it a non-economic right? Because the Copyright Act contemplates that every author, apart from, or an artist or an author in that sense, when he makes a work, he does not only do it for his commercial exploitation, which may be, but moral rights are given because that work somehow really, in that sense, adds to the cultural heritage, or it really adds to the culture of that particular community or that particular nation, as we will see in certain cases. But this special right which an author has, that has been categorized into two parts. One, as Veerendra sir has already explained, paternity rights and right of integrity. Paternity right means what? If I have made the work and if I have written, say I've written a song, and if I have assigned it to somebody, somebody has made a sound recording of it, they've made a song of it and they have sold it. They may keep assigning the right in the song per se to anybody. But whenever that song will be played anywhere, I will be entitled to get the credit. The credit will always be there. This song, these lyrics have been written by Hiren Kamod. So I may assign my right to somebody, to a commercial entity, and that commercial entity will keep assigning it to God knows so many people. But whenever it is used, I will be always given a credit as an author. That is called as the paternity right. Actually, I saw one video where a Canadian woman was explaining about this, and she actually took an exception, saying, I don't like this term paternity right, because why should it be paternity right? Which I thought was quite interesting. But that is from paternity right, because basically it is right to claim that this is mine and it belongs to me, it originates from me. Right of integrity is something which is very important, because paternity rights is open and shut. If I am the author, I will make a claim, and I have to, and the court will look into it whether I am the author, and the credit will be given. Right of integrity is something which the litigation, or generally the entire, in that sense, whatever the courts have held, it all revolves upon this right of integrity. Why does it revolve around the right of integrity? Is because, see, this is how, as Veerendra sir explained, but I've just taken from 57, this is what moral rights really in that sense mean. Right to claim authorship of the work, and right of integrity, because section 57 says what are author's special rights. Section 57 says, and this is the right of integrity, right to restrain or claim damages in respect of what? Please read these words very carefully. Distortion, when you distort the work, when you mutilate the work, when you modify the work, or other act in relation to the work, if such distortion, mutilation, or modification or other act would be, people please read this line very carefully, prejudicial to his honor or reputation, which basically means if any work is distorted, mutilated, or modified, and that word modification or any other act, so it is such a wide right. The intention of the legislature is to give the widest possible interpretation or widest possible ambit to this right of integrity. In other act in relation to the said work, if such act or such mutilation, such distortion, modification would be prejudicial to his honor or reputation. Please see the words which have been used. The words are honor or reputation. They could have very well, the legislature could have very well used only the word reputation. They may not have used the word honor, but it says honor or reputation. Now, reputation, what is a reputation? As we will see in one of the Delhi High Court judgments, which I'll be showing you people. Reputation means a reputation that I have achieved by carrying out my profession, by exercising what I have been doing professionally. Reputation amongst lawyers, or general my reputation. But honor, the court says that honor is something more. Honor has to do with something with integrity, something with dignity, something that is very personal to me, something that makes me proud of who I am, which shows basically my work shows what I am, what I am made of. So therefore, this honor is on in that sense really for interpretation is on a little higher pedestal than a reputation. Moral right therefore is a right to claim authorship, and two, that if I write a song, which I give you an example, I write a lyrics of the song, I give it to a record company makes a song out of it, then that record company gives it for other digital remixing, whatever they do. I will not have any right because I have assigned all my commercial right. But moral right, I have not assigned. Under the copyright law, how sir said, we cannot assign moral rights. We cannot assign license moral rights. Moral rights are very inherent to the author. So you can't assign it. You can't license it. They will remain with you forever. Which means if today I write a poem and as I said, if I give it to a company and company ultimately exploits it, and after whatever say 25 years, somebody takes my lyrics and somebody distorts it or mutilates it or in that sense does anything which is prejudicial to my honor and reputation, I can then file a suit and restrain him from doing it even after whatever 25 years, 50 years, whatever. Here, so this is basically what a moral right is. Here, what is important is the Berne Convention, which Veerendra sir explained. Berne Convention 6 IB says that Berne Convention, what is Berne Convention? Berne Convention is basically the minimum standard of protection that is required to be given by all the member countries to the copyright in the artistic and literary work. The minimum standard which is to be given. All the members who become a part of the Berne Convention, they have to basically oblige by it. Now this Berne Convention came in 1886. In 1928, as Veerendra sir said, in 1928, moral rights were made a part of Berne Convention. Immediately in 1957, and we must be very proud because Indian Copyright Act was one of the first few ones. In UK, they adopted moral rights in 1988. In US, they adopted it in 2000. In 1957, India made a provision in section 57, which provided for protection of moral right. But I feel India went a little overboard. Why did India go overboard? Berne Convention said moral right is right to claim authorship of the work and right to restrain or claim damages in respect of distortion, mutilation, modification if it is prejudicial to his honor or reputation. And the Berne Convention said that minimum right which is to be given, minimum right which is to be given to moral rights, minimum tenure which is to be given to the moral rights is still the existence of the economic rights. So for example, in an artistic work, 60 years after the author dies, you have an economic right or right to commercially exploit. 60 years in a literary work, 60 years after the author dies. So Berne Convention said minimum tum na 60 saal ka, whatever is your, that time tum copyright, whatever your act gives for economic rights, give moral right the same kind of tenure. But India went overboard. 1957 में जब वो section introduce किया गया, there was nothing to talk about tenure. So it was assumed and it was taken that the moral rights are there for perpetuity. So even after 200 years or 150 years, my legal heirs will be able to enforce my moral right if somebody distorts my work. So this was something which happened. Ultimately in 1994, this was amended. And it was amended also because of a very interesting reason. And I'll come to that reason when I come to that slide. In 1994, this was amended. An addition was brought into the act which said that till the existence of the copyright. So therefore, then the moral rights were not in perpetuity. They were only made till the economic right exists. This happened in 1994. And in 2012, when the amendments have again happened, in 2012, that economic, till the time the existence of economic right has again been taken out. So as we speak today, friends, moral right is there for perpetuity, which means, and moral right is not only moral right is there for perpetuity, but the sections also provide that moral right can be enforced by my legal heirs, which means after 200 years, if there is some nice poem which I have written, which I don't write generally poem, but if I would have written a nice poem or a nice lyrics of a song, and after 200 years, if somebody tried to distort, my legal heirs could have taken they can take action against such kind of distortion. So moral rights are there for perpetuity. The reason for me to tell you this is because I want to make you understand how moral rights are really very important and they're not taken very seriously. But moral rights in today's day and age, with the technology advancing, there is a lot of importance which is given to the moral rights, and all these amendments which actually show that the intention of the legislature is also to give moral right, make it an inherent right and give the widest protection to moral rights. This moral rights also originated really from France. France is a civil law jurisdiction and their moral rights are actually on a very different pedestal. Moral rights can't be waived. Their moral rights are taken very seriously, and therefore this is a classic case which happened in 2004. Victor Hugo is a very famous novelist who writes a lot of books. And 1862, he had written a novel called as Les Miserables. Pardon my pronunciation because I'm not very used to French pronunciation. So Victor Hugo in 1862 had written a book. And that book, and as I said, moral right there are taken very seriously, which can be enforced by their legal heirs also. In 2004, there was a book which was written by some other publisher, but it was like a sequel, which was taken, the character was taken, and this is happening, mind you, 1862, more than 140 years later, she said that, I want to ensure that this Les Miserables, which is the original work of Victor Hugo, this must go to all the people. So she made, of course, some modifications, and she made a complete and new version out of it in 2004. The great grandson of Victor Hugo approached the French court The first court first threw him out, saying that you can't prove that you are the legal heir. So they threw him out. He went into the Court of Appeal. Court of Appeal said, no, you are the legal heir. And there the Court of Appeal granted injunction, saying that, because as I said, the higher threshold of in our country to show modification, distortion, mutilation, or any other act which is prejudicial to the honor or reputation. That prejudicial to the honor or reputation is extremely diluted in France. So there, the moment it was a modification, or moment it was in that sense of work, which was some other treatment to the work, the legal heir went and the Court of Appeal there granted injunction. After the Court of Appeal granted injunction, the publishers of the new book approached the Supreme Court there, and their Supreme Court in 2004 said, no, freedom of speech and expression is important. He has not done anything, because the plaintiff also did not claim that what the defendant has done or the new publisher has done amounts to distortion, or it amounts to lowering my great-great-grandfather's integrity or whatever. The only thing was, don't allow him to do it because this is violation of the moral right. So there the court in 2004 said, no, there is a freedom of speech and expression, so long as he has not tampered with in that sense or affected your honor or dignity in that sense, there can't be any injunction which can be passed. And this created quite an uproar, because France, as I said, is a civil law jurisdiction where these moral rights are taken very seriously. But for the first time, the court here took a little balanced approach in that sense. This was a case in Canada, very interesting case. Everybody can see these bird-like structures which are there, flight stop they were called. These were made by this guy called as Michael Snow. He was the author, or he was the guy who created it. And then this was kept in Toronto, in one of the biggest exhibition centers in Canada. And then he had designed it and he had given it to them and they had put it there. Now, during some festival, the publisher or the mall owners got into some festive spirit, and they actually put ribbons. I don't have that photograph, but they put ribbons all across these birds that you see. When Michael Snow saw that, he said, boss, this is absolute infringement of my moral right, because people who understand all this art and people who understand what I have done, what you have done is actually distortion by putting those ribbons and all. It just takes away the aesthetic appeal, and this is something which is derogatory, or in that sense it is prejudicial to my reputation and honor. He went to the Court of Law, and the Court of Law upheld it and directed the mall owners to immediately remove the ribbons in order to ensure that it is displayed in a manner in which it was created, so as to protect the integrity of the author. In India, the first ever litigation or judgment which happened on moral rights surprisingly came after 30 years after moral rights were made a part of our statute. Our statute is of 1957 Copyright Act, which had section 57 that time also. 1987, 30 saal lag gaye pehla case aane ke liye for moral rights. This was an interesting case. Plaintiff was an author of the book Aapka Banti. In that book really spoke about some social problems, about divorce and how the divorce generally has effect on children, and how children are very sensitive, and children can sometimes go to some extreme limits, take some extreme steps if they are not handled well. So it was a very, in that sense, a social issue on which this Aapka Banti book was written. Rights were given by this Mannu Bhandari to Kala Bhandar Pictures Private Limited to make a movie out of it. Now, when the movie was made, when the plaintiff saw the movie, the plaintiff was taken aback. The plaintiff said, you have distorted the characters. For example, she said, the first husband in my book, he was an executive in a good bank. He was a good person morally. In your book, the same character, you have shown him some notorious businessman and some person who has no morality, and he does certain stuff which is not, in that sense, which is vulgar. And she said, the overall treatment which you have given to my work is absolutely vulgar. So I gave you the copyright. I assigned you my right of adaptation to make a movie out of my book, but you don't have a right to distort something which affects my recognition or which affects my goodwill or my reputation, because ultimately sabko pata hai ki Samay Ki Dhara is a movie which is based on Aapka Banti. People will associate it with me. So she immediately approached the Court of Law, because the defendant said they did not agree to her. She went to the Court of Law. And this is an interesting judgment for two reasons. Because first judgment which talks about section 57. But here, after the arguments, the matter was actually settled. And the court records it. That though the matter is settled between the parties, both the parties and the advocates requested the court, because there was no judicial pronouncement, they said, you please, because you've heard the matter, you give a judicial pronouncement on this aspect. And here the court, something which is something which is very nice. The court said, as when I began, friends, I associated moral rights with the cultural heritage. So our work has, of course, you will have economic right, but it has something more also. That cultural heritage part, there the court said that enrichment of culture is of vital interest to any society, and law protects this social interest. So therefore, they said section 57, according to me, that is what the court says, section 57, according to me, is something which is very special, which is something which is beyond the, in that sense, material gains of copyright. And it puts the author on a special status. And if that is the case, then you cannot distort it, because you are also tampering really with the cultural heritage or the culture of a country. And that was again reiterated by Delhi High Court, where I'll come to. But this is actually what the first time Delhi High Court in Manu Bhandari High Court in the case said. Hallmark of any culture is excellence of arts and literature. Quality of creative genius of artists and authors determine the maturity and vitality of any culture. Art needs healthy environment and adequate protection. The protection which law offers is thus not the protection of the artist or author alone. Enrichment of culture is of vital interest to each society. Law protects this social interest. Section 57 of the Copyright Act is one such example of legal protection. Section 57 lifts the author's status beyond the material gains of copyright and gives it a special status. This submission raises an important question of an aspect of court power under section 57. The court does not sit as a sentinel of public morals or super censor in exercise of its power under the said section. It cannot impose its views on sex or its depiction in the work of art. The concern of the court is to examine how for the new avatar is true and authentic and what changes are necessary due to constraints of a medium. Counsel for the parties have requested me to pronounce a judgment as there is no decision of the court of law at this stage, and particularly on interpretation of section 57. Here, because the court ultimately told the defendant, you improve this, you change this scene, you do this, and then it will be fine. But ultimately the matter was settled. But this laid down that principle which was then reiterated by Delhi High Court, which I'll come to. But it laid down that principle that author's work or the moral rights really have to do something with the cultural heritage. And it is not only the author as such, but whenever the author is doing some work, he's also contributing, or is in that sense taking the cultural domain or cultural heritage of the country further. This is the how Kesavananda Bharati is there on Constitution. This is the Kesavananda Bharati insofar as the moral rights are concerned. Amarnath Sehgal versus Union of India. In 1957, the case is very, very interesting. In 1957, before viewers start reading it, 1957 was the time which was after the World War II. You know, there were two groups. One was American group and one was the Russian group. Nehru started the policy of non-alignment. We will not align with anybody. Because that time Nehru realized India in that sense will be a group leader of all these countries who are going to join this non-alliance movement. He realized that there will be a lot of delegates who will come from different countries, and therefore we need to have a state of art, a nice exhibition center where the delegates can come, we can have conferences. And the idea of Vigyan Bhavan that time came. There he commissioned this Amarnath Sehgal, he's very well known. I don't have to tell you people about him. He was commissioned to create a bronze mural for this Vigyan Bhavan. Now, mind you, Amarnath Sehgal was a person whose bronze murals were actually gifted by government of India to President Carter, President Nixon. All of them, as in these people, were actually given the work of Amarnath Sehgal. So, just to point out that he was a very well-known person, and his work was credited by everybody. He took some 5-6 years in order to make these murals that you see. These were bronze murals which were put. And this photograph is an interesting photograph where you can see Mr. Sehgal himself, and you can see Pandit Nehru also, where he is overlooking as to the work which has been done. In 1979, the government had changed, and then the government decided to relocate the mural, and in the process they damaged the mural. Actually, they didn't decide to relocate the mural. What they did was they removed it and they put it into the godown. Now, while removing those murals, there was some damage which was done to the murals, which Mr. Amarnath Sehgal realized. He immediately started corresponding. He immediately started writing to the authorities saying that what you're doing is incorrect, because in that sense, this is like a national heritage. This has a lot of cultural importance, but they paid no heed to it. He had to therefore file a suit. he filed a suit against Union of India. 1992, an ex parte interim relief came to be granted. And this ex parte relief gives a gist of what the court was subsequently going to hold, where actually the court said that the right of integrity ultimately contributes to the overall integrity of the cultural domain of a nation. And in this case, for ex parte, this is what the court said. The court was extremely upset in the manner in which Mr. Amarnath Sehgal or his work was treated by Union of India. So on 1992, this is what Justice Jaspal Singh of Delhi High Court said. By then, dead eyes and deaf ears do not respond. This he is saying in the context because Amarnath Sehgal wrote to the authorities, but they did not respond. They did not even respond to the legal notice. Hence, this suit for damages and injunction, restraining any distortion, mutilation, or modification of the work. In a country rightly proud of its creativity and ingenuity, men who can hardly distinguish the heads of Venus from those of Mars, here he is being sarcastic, cannot be allowed to decide the fate of artists who create our history and heritage. The cry is, illness passer not pass. And in such a situation, Indian court will always be found dynamic and responsive. Section 57 of the Copyright Act provides the light. It's a small order of 2 pages, but it actually laid down after what Manu Bhandari had held in 1987 in that judgment. Here the court actually said that you need to protect in that sense the creativity because they ultimately add to our culture and heritage. Interestingly, friends, this happened in 1992. After this judgment came, immediately in 1994, there was an amendment. So till 1992, as I said, the Act said, one, the moral right was given in perpetuity. And the original section 1957 said, first right is to claim authorship. Then it said, right to claim damages in respect of distortion, mutilation, or modification of work. Or, and then third, any other treatment to the work which will be prejudicial to the honor or reputation. So earlier, before the amendment, the only criteria was mutilation, modification, or mutilation, distortion, or modification of the work. The requirement of prejudicial to the honor or reputation was not there till 1994, till the amendment was there. 1994, immediately after this order, there comes an amendment. Amendment then says, not every modification, every distortion, or every mutilation. Every modification, mutilation, and distortion, if that distortion, mutilation, or modification is prejudicial to the honor. This was the amendment in 1994. And most importantly, the amendment then came up with an explanation. There is an explanation to section 57 now, which came in 1994 and it continues today. That explanation says, if the work is not displayed, or if the work is not displayed to the satisfaction of the author, that will not amount to infringement of moral right. Now, this is something which was not there originally, but after this 1992 judgment, in 1994 amendment, this explanation was provided that if I decide not to display the work at all, or if I decide to display it, then the author can't come and say, कि अरे नहीं इस पे focus ज़्यादा करो, तुमने वो पीछे रख दिया, this is therefore my honor and this thing is getting affected. So this explanation was introduced in 1994. Thereafter, finally, when this matter came up for hearing, the suit came up for hearing in 2005, Justice Pradeep Nandajog has in fantastic words laid down the law. And I must say, I have gone through the arguments. Mr. Praveen Anand argued the matter, and the arguments which have been advanced and what has been held by the court is fantastic to read. And I will urge all the viewers, I have given the citation, to read this judgment to understand why right to moral integrity is actually something that adds to the cultural heritage of a nation. This is what the court says. Authorship is a matter of fact. It is history. Knowledge about authorship not only identifies the creator, it also identifies his contribution to the national culture. It also makes possible to understand the course of cultural development in a country. Linked to each other, one flowing out from the other, right of integrity ultimately contributes to the overall integrity of the cultural domain of a nation. Language of 57 does not exclude the right of integrity in relation to cultural heritage. The cultural heritage would include the artist whose creativity and ingenuity is amongst the valuable cultural resources of a nation. And this is a line which really shows what the court thinks of section 57. Through the telescope of section 57, it is possible to legally protect the cultural heritage of India through the moral rights of the artists. So the court has really put the moral rights concept on such a high pedestal by saying that you are not only protecting in that sense the dignity and honor of the author, but because that author, when he writes, he contributes really in that sense also to the cultural heritage. This is a way to protect the cultural heritage of the country also. So this judgment I urge everybody to read, because as I said, it will throw some light on as to what the court considers the moral right to be. In 2005 then, an attempt was made in this case to say that section 57 of the act, which is the author's special rights, also include the right to withdraw or retract his work. Right to claim authorship is there, right of integrity is there. Let me tell you, in Germany, in France, in the jurisdiction, they have an additional right called as right to withdraw the work. So which means that in 2020, Hiren Kamod wrote an article about the capitalist view. What do I feel about capitalism? I have written it. In 2040, I feel, jo maine likha tha, now my views have changed and I don't want to be of that view anymore. I am given a right as an author to withdraw. If there is a publishing house, I am given a right to tell the publishing house that my views have now changed, hence you will not publish it any further. Of course, then there is indemnity to be given and there are other parameters which are there, but that right is recognized. Now, this is done by France and Germany, but mind you, this is not a criteria which is there in the Berne Convention. Berne Convention does not say about all this. Berne Convention only talks about right of paternity and right of integrity. This was a case where the rights were assigned by the defendant to the plaintiff. Plaintiff started publishing the book. There was one clause which said the author, which is the defendant, which I stated in the second one, clause stated author could withdraw the book after 2 years if not satisfied. This was a general clause. The defendant, the author who had given the right to plaintiff, he wrote a letter saying that all right boss, now I don't want you to publish it, now stop it. There, when the plaintiff approached the court of law and the plaintiff said, no, the defendant relied upon that clause to say there was a clause which said to withdraw the book after 2 years. I have withdrawn it. Now what is the problem? Plaintiff said, no, that clause which was put, it was put as a moral right. That clause really recognized the moral right of Nina Khanna and others in that sense. Therefore, that clause was only in respect of moral rights. In that context, the court said, no, that clause could never have been in the context of moral right because I need not mention about anything about moral right in my agreement, because moral rights have nothing in that sense to do with your contractual obligation, because as I said, moral rights can't be assigned, moral rights can't be licensed. And there the court in that sense that it does not. And about the plaintiff argued that, this moral right really is that right of withdrawing. And therefore, that moral right was contemplated in that clause. The court said, no, our section 57 is in consonance with the Berne Convention. Our section does not recognize any withdrawal right or any retraction right. And therefore, that was not considered as a part of moral right. Quickly, Chashme Baddur, the famous Chamko one, which I have also seen in olden days. There was a movie which was made in 2013. The original producer, original script writer, story writer, Sahi Paranspe had assigned all the rights in the script, in the everything to the director, to the producers of this film. In 2013, when Chashme Baddur, this film was made, suddenly the plaintiff, Sahi Paranspe, approached the court of law on the ground that this film really, in that sense, gives a bad name to me, my image will change. And there are certain contents which are vulgar, which are not good, and therefore my moral rights are affected. There was no denial insofar as the copyright or insofar as the assignment of the copyright is concerned, which was done way back in 1980s. But the plaintiff said this amounts to infringement of my moral right. There incidentally, and Veerendra sir will throw some more light, because Veerendra sir argued for plaintiff there in this case. There the court, however, distinguished it by saying, because the plaintiff there, before coming to the court, plaintiff had written to the Film Writers Association, and there her complaint was, please read, interestingly in the said complaint, the plaintiff complaint which was filed by plaintiff before the Film Writers Association, the plaintiff has only alleged in the complaint that by doing her remake, her name and image as a filmmaker stand in danger of being corrupted by association, and that her moral right, therefore, along with the copyright, have also been violated. There was not a whisper in the said complaint about the alleged vulgarity and obscenity in the said film, as was alleged in the plaint in the first time. So the court distinguished it, and ultimately, really, the court refused to give any ad interim order because the court said there the plaintiff approached one day before the film was going to be released, and the court really rejected the plaintiff's application on the ground of delay. But the court also said, which is important in para 8, the court said today at such a short notice when the movie is going to be released tomorrow, only on the basis of allegations, just because plaintiff is saying, I can't decide. And the court said the court will also be required to see the both films and decide the context in which the word, statement, actions are used, shown in the movie, and decide whether the movie smacks of vulgar obscenity, which cannot be done just a day before the release of the film. So this was actually done way back in 1987 in that Manu Bhandari case also. The court had to actually view the two works. So that principle was taken further. Here also the court said, I had to view the work. Without viewing the work, I can't do anything about it. But ultimately, as I said, ad interim was rejected on the ground of delay, saying that there was a delay for the defendant to come to the court. And then ultimately order was not passed. And later the matter was settled, I believe, because the suit was withdrawn. Quickly, Sholay, everybody knows Ram Gopal Verma ki Sholay, Ram Gopal Verma ki Aag. Here, the Delhi High Court has passed this order where the Delhi High Court said defendants have distorted and mutilated the original copyright work of the plaintiff. Defendants have infringed the moral right of the plaintiff. There is a finding, but there is no discussion on it. But I had to include it because as it is moral rights, there are a lot of cases. But the court, after seeing the entire evidence, the court came to a conclusion that the moral rights were infringed. This brings me to the last and the latest case of moral rights, which has been decided by Justice of Delhi High Court. Now, please look at this, that how the concept of moral right can in that sense be taken and logically to some another or to a dimension which is little different. Raj Rewal, who was the architect of these two buildings, Hall of Nations in New Delhi and Nehru Pavilion in New Delhi in 1972. Again, Raj Rewal is a very, very famous architect. He had built this. Also, again, the government of the Delhi the government of Delhi wanted to build this. Therefore, the government of India wanted him to build it. Therefore, he had built it, and these construction and it was constructed, and these buildings were there. What happened in 2017-2018 is that the government decided to demolish these structures in order to bring something new there, or basically have a new building there. There, Raj Rewal then, relying upon Amarnath Sehgal case, of which I showed you about the bronze mural, he filed a suit for violation of moral right or infringement of moral right on the ground that, listen, I am the architect of this building. I am the author of the artistic work on the basis of which this work of architecture has been, structure has been made. He therefore said that once it is done, once this building is built, I am the author of the artistic work on the basis of which this is done. So if you destroy it, it amounts to mutilation, and therefore stop the defendant from destroying it. Now, the moment he got to know that these buildings are to be destroyed, he immediately sent letters to the Union of India saying that don't do it, this will amount to infringement of my moral right. The Union of India there also did not even bother to reply, and by the time he could go and file a suit, the structures were demolished. He immediately approached the court and he said, I have now approached the court saying that this work should be compensation must be given to me for the violation of my moral rights. Pausing here for a second, in the Amarnath Sehgal case, the bronze murals were removed and kept. But Justice Pradeep Nandajog, when he decreed the suit, he said that give those back to the author so that he can do what he wants to do with it. And a 5 lakh rupees or 10 lakh rupees cost was also imposed. Similarly, here the court, because by the time he filed the suit, Mr. Raj Rewal filed the suit, the buildings had come down. So he filed a suit saying that A, compensate me in terms of money, and number 2, restore those buildings. Now here, Justice Enlaw, again a fantastic judgment written by Delhi High Court, where Justice Enlaw had to really, in that sense, balance out. He said that how can it be that generally, forget about the work of architecture right now. Copyright lies the moment you express your idea onto some medium. So therefore, for an artistic work or literary work, the moment you write it on a medium, there is copyright. But in work of architecture, it has to be on a land. Now that land, most of the time, that land may not be my land. That land may be somebody else's land. So how can it be that if property, if the land belongs to me, and if there is an architect who has been appointed, we build a building as per his architecture, I want to destroy the because I'm the owner of the land, I want to destroy my bungalow and build a new bungalow. How can he stop me from doing it? So all these things had to be considered. And Justice Endlaw passed a very good order. Even this judgment, according to me, everybody must read, where the court actually said that 57B has to be necessarily interpreted as entitling the author or owner of a copyright to only restrain the owner occupier of the building from dealing with the work of architecture in the building to make the building look otherwise than as designed by the author architect. Public viewing the building is such altered form is unlikely to know that alteration therein is not the work of the architect to whom the architecture of the building is attributed, and such altered architecture of the building may prejudicially affect the honor and reputation of the architect. Just like the purchaser of a work of art, copyright wherein vests in the artist is entitled to not to display the same, so also the owner of a building, even if an unclaimed piece of architecture, cannot be restrained from demolishing the same and making a new building in its place. Also, here the Delhi High Court said that how it is a constitutional right to have your land as a property, and if that right is being affected by something as moral right, in that sense, the court said that then the constitutional right to have that right of your land as your property will be a higher right. This is what the court ultimately said. But this discusses various interesting propositions which you must read and you must consider and try and apply to all the day-to-day examples that we have. Quickly now, I come to the last 2-3 slides of my presentation on moral rights. I had to include this. I am sure whoever is viewing this webinar, they know that the moment it was about moral rights, this dispute had to come. We all know what the dispute is about. A song which was originally claimed to be written by Ratan Kahar in 1970, a folk, and later it became a folk song, but it was initially written by him, but which is very special for a specific community in Bengal. And that song which has been existing for a long period of time, and it is a very famous song, as I said, in that specific segment of a community in Bengal. I have actually taken us to help you understand what exactly the dispute is about. I'm actually going to play the original song which has been written by this Ratan Kahar, and this was actually in 1976. This was sung by the singer, and it was available on I have taken help of my friends who understand this language, and they have explained to me what she's saying is, she's an unmarried mother who's telling her daughter that you have beautiful hair, and you know you are so beautiful because your father is a very rich man and a good looking man, and your hair is long hair, and let me put genda fool in it. This is what the mother is telling the daughter. And as you can see the music behind it, and you know the manner in which they are dancing, this became like a folk, in that sense, a folk song, where it in that sense shows the culture, in that sense shows the heritage of that specific community of the country, specific community of West Bengal. And then we know this song was recently used by Badshah, and it is a remix. He made his own composition, but he heavily relies upon and takes the musical notes also and the lyrics also, and this is how Badshah has made use of it. Things here. The controversy is there because apparently Badshah did not give the credit to Ratan Kahar. Even today, when I saw before the presentation, the official song which is available, it only says Bengal folk. It does not give credit because the contention, as I've read from the newspaper reports, contention of Badshah was that I did not know this was made by Ratan Kahar, and there is nothing in record to show it was made by Ratan Kahar. Assuming for a second that it was made by Ratan Kahar, ultimately, it will have to be decided whether, apart from the infringement of copyright in the literary work, which is the song which he has written, would this also not amount to infringement of a moral right, where you take a particular kind of work, which as the Delhi High Court also says, that moral right really has to do with the cultural heritage. So you take a song which shows some culture, which resonates the sentiment of people. You take that song, and then you give a different kind of, I won't use the word vulgar, but a different kind of connotation to it. And then you use it in your own composition. This is something that ultimately the courts will have to decide whether this would amount to distortion, mutilation, or doing any other act which is prejudicial to the reputation or which is prejudicial to the honor of the author. And this brings me in a way to the last slide. Again, as I gave you the example of this Baksha song, you have to also analyze this kind of a principle, because when I was thinking, the famous song of that Nanna Munna Rahi Hu, Desh Ka Sipahi Hu, Bolo Mere Sang Jai Hind Jai Hind. Now this is a nice song which has been there. After 50 years, take an example, somebody takes this song and then puts some kind of a vulgar, or let me say like a sexual connotation to this song, and then put something and some cuss words are put in between the song. Would it or would it not affect the moral right? Because that song really resonates the sentiment of people. It really shows the culture in which my parents, they were brought up, I was brought up. After 50 years, just because time has passed, it would not really change the sentiment of people or the cultural contribution of that kind of a song. Just to give an example. So therefore I said, take an example of that song using, and then if there are cuss words in between, would that not amount to really, in that sense, violation of moral right? This brings me to my last slide. In the lockdown, as most of you must have also done, yes, I saw Money Heist. And Bella Ciao is, as we all know, it's one of the famous, now it has become even more famous. But did you know that Bella Ciao really, this has its place in Italy. Bella Ciao is actually an Italian protest folk song. So we don't know who the authors are. So there can't be any infringement of moral rights in Bella Ciao at all, because we don't know who the authors are. But this song was used by Italians, when during the hardship they had to, this Mondina women, the paddy field workers in 19th century, they used to sing it to protest any kind of hardship that they were going through. If you see, this was used later as an anthem by anti-fascist Italian partisans during the Italian resistance between 1943 and 1945. So during the realm of Mussolini, this song was actually used as resistance, to resist some kind of suppression, oppression, or to resist, these fascist forces which were coming. If you have seen Money Heist, this again has been used in the context of resistance. This song, I was impressed to know that Japanese, Mandarin, English, Spanish, Arabic, name it, and all the countries, whenever they people wanted to resonate that emotion of resistance or something to go against the government or something that they stand together for against suppression, they have used this song. I actually found out that in India also, in New Delhi, during the attacks on JNU, when that happened, they actually came out with a version of this song called as Mat Jao or Hat Jao. So point is, this is a song which really in that sense resonates with that kind of a culture, and people will remember the sacrifices, how they stood together and how they decided to stand against suppression. If that is the case, I ask you a question. I'm going to play this one version which is available online, which will show that how this song has been used throughout in order to show. See people protesting, coming together, making resistance. You feel it, that they are singing, they are talking about their, the lyrics are also so beautiful. If you actually translate, they actually talk about this only, how partisans, what will happen, and basically to deal with how you will, how injustice was done and what would happen. Now, I came across this version. So in that kind of a song, in between to have cuss word and then mixing that song where partying, dancing, of course, partying, dancing is not bad. I'm not on that. I'm just saying, when you actually, this may be an example where you actually treat the song in a manner. If there was an author to this song, probably he would have also come up saying that there is distortion and something which is prejudicial to my honor and reputation, because this was not the intention when the song was made. With this, I come to my last slide. Thank you very much. I tried my level best to make it interesting, to give you good examples, and to at the same time show principles of moral rights and personality rights. Thank you so much. You were a great audience.
Thank you, Hiren. That was amazing. I think all of us over here have really benefited a lot with this presentation. We have almost over 61 questions from our participants. I'm not sure if we'll be able to address all of them. But as we promised, we'll have an interactive session now to just address some of the repetitive questions which have been coming. So Veerendra sir and Hiren, I think one of the key questions which I can see is on waiver of moral rights, which you all have addressed in your respective parts. Veerendra sir, you did mention that according to you, moral rights can be waived if it is specifically waived and not generically waived. So,
Yes.
So in that context, and most of the media lawyers over here would agree with me that every agreement these days, be it with an author or be it between production houses, requires a moral right waiver clause, because the end parties, they want to have the freedom to modify the content to the way they would want. So according to you, if such a waiver is present in such agreements and there is a distortion or mutilation, does the original author have any recourse?
If he has waived it with reference to his specific work, then he will not have any right to complain. But if it's a general waiver, then he may be able to complain. So it has to be specific. Waiver has to be specific with particular work.
Noted.
Not general waiver that I waive all my moral rights in all works which I hereafter make.
Noted. Hiren, are you of the same view that if such a waiver was to be tested in the court, would it be enforceable?
Here, maybe because of so much research which I have been doing, maybe I'm thinking only in one perspective. I have to sometimes calm down and think from the perspective of the assignees also. But somehow I felt that the intention of the legislature to make distinction between moral right and economic right was, if you can't assign license, maybe you can't waive it, and I feel because the courts also in a way say in the Delhi High Court judgment, the court said it adds to the cultural heritage. So if everybody in that sense starts waiving, then what would happen? As in that is what the courts have held, that that section 57 really is beyond the material gain. So I don't know, as in, so that is my view. But if at all the concept of waiver would be there, it would be exactly what Veerendra sir said. This is as in, it does not apply to my common sense, that how can you say that every work that henceforth I will do, I'm waiving all my moral rights. That will be difficult. But as sir said, specific work, a specific waiver may be there if that concept is accepted of waiving.
Fair enough. So just an extension of the same question. As you may know, after the 1977 IPRS versus this IMPA judgment by the Supreme Court, most of the labels and production houses of those times stopped entering into agreements with the authors. So between the 80s and 90s, you'll see there was a stage in which there were no agreements at all with the authors. In that case, now that there is a trend of recreated versions and remixes and all of old tracks being made, what do you think would be the position with respect to those situations where there is no agreement at all between an author and a producer, and the rights, obviously because of the 1977 judgment, are vested with the production house or the label?
I think some agreement will have to be spelled out from the conduct of the parties. It can't be that there is no written agreement, therefore there is no agreement. It will depend on the evidence.
So, Veerendra sir, as we saw in Hiren's presentation, with respect to the recreated versions that you see these days, do you think that would come under it being prejudicial to the honor and reputation of the original authors?
That again depends on what type of work which is created. If it does, then the remix also will amount to a violation of the moral rights.
Just to add here, what sir said is absolutely right. And this moral right concept, Anushree, this concept of reputation and goodwill, this was specifically discussed in 1948 Berne Convention. When they met in Brussels in 1948, they actually discussed it, that does reputation and honor mean the same thing? Then they came to a conclusion that no, they are understood to be two different things. And then there is actually discussion on the fact that, so what? Right of integrity, is it integrity as an author, integrity of the author regarding the work, or integrity of the author generally? So whether when you say that it is prejudicial to the honor or reputation, so right of integrity, whether the right of integrity is regarding the work, the manner in which he has done it, or is it to him as a person, as in, what were the traits of him as a person? And 1948, all the countries then agreed that this right of integrity means both right of integrity to the work and as a person also. So for example, a Hiren Kamod or Veerendra sir, is if we were writing only say poems in respect of nature, only nature, good things about nature in a way. So our trait, or in that sense our honor, or in that sense, what would be associated with us are like, in Marathi we call it as Nisarga Kavi or something like that, that would be the trait. So even that will be considered. So I hope I'm making myself clear. So therefore that trait of a person, that would also be considered while you are considering whether it is prejudicial to the honor, that right of integrity.
That's an excellent point, I think, for all of us to hear that. There's one more question on moral rights. A lot of films which were like black and white films are now entering into public domain. 60 years from their publication have expired. So would colorizing such black and white films amount to moral right violation? Veerendra sir?
If the copyright has come to an end, then it will not be.
But the moral rights would still be in perpetuity. So
it is not. That's what Mr. Hiren explained.
No, sir. 2012.
As far as we are concerned, it looks like that it is in perpetuity. But again, making a color film, will it amount to that type of modification which affects the honor, or it increases the honor?
Correct.
That will have to be seen.
Correct.
On personality rights, I would like to ask a few questions, and then we can maybe take a few questions from the audience. On succession of personality rights, Veerendra sir, do you think that it can be passed on to the legal heirs? For example,
so long as reputation stands, it can't be after 200 years, 300 years.
So say for example, if Mr. Bachchan wanted to make a will and pass on, because publicity rights and making biopics these days have a lot of commercial value. So would he be able to, write in his will to one of his legal heirs?
Let Mr. Hiren answer that question.
No, what sir said exactly. I feel you can give that right to your legal heir, and what sir said, is very important. That for a third party to make it till the time that right publicity, till the time that reputation is there. After that I agree.
So, what about a person holding a public office? Say if I was to make a film on Rahul Gandhi, or even better if it's Jaya Bachchan. Now, in this case, what would you say? Because they are holding public office, they are public servants. So their life is actually a part of, it's like a part of the public record. So do you think that in that case also personality rights, the same position applies to public figures?
It depends. You will have to take consent for making that film. Her consent will be required.
But say
and if you confine your work to the material available in public record and not islas which are not available in public record, you will be committing the offense of committing the violation of moral rights.
Okay. Hiren, are you of the same view?
Yeah, because, and what you are saying, even if they are public officials, as you said, this question was answered by Supreme Court in that 1995 Rajgopalan case. Because there, it was not more than the right of privacy of that Auto Shankar, it was about the right of privacy of those police authorities who were named. And it was said that kisne paise liya, kya kiya, whatever. So there they were also concerned with that. So in that context, there is also a comment, or there is also an observation made by the court wherein they say that this will apply even to, in that sense, public authorities. The public record will be the record which they have said in their in the judgment, which I mentioned during the presentation. Anything more than that, you have to seek permission. Otherwise, there will be a problem.
Fair enough. And what about mimicry artists who, who mimic a lot of celebrities? Do you think those acts amount to personality right violation, Veerendra sir?
No. That's your personal right, which is given to you, freedom of expression. You are also an artist if you are mimicking. If you are doing mimicry, you are yourself is an artist. So that is given as it is given to the parodies.
I was just going, sir, that is absolutely. Parody is really the answer. It can't be under the garb of moral right. You are stopping. This is our personality right in that sense. That's what Delhi High Court said. No, that word of caution, that your freedom of speech and expression is your constitutional right. So of course the court will balance it. But if at all it comes to that there is in that sense of conflict, that right is the highest right. So as sir said, when I am doing mimicry of somebody, I am myself an artist. I have my freedom of speech and expression to do that in that sense. So therefore, according to me, that won't be a violation of.
So long as while doing that, you don't defame anybody.
Derogate.
Great. So I'll just quickly take a few questions which we have from the attendees. There's one question which asks, what's the criteria adopted by courts to decide well-known personality?
Well-known personality?
Yeah. As in, how do you decide that who is a well-known figure, who is not?
But that like a defamation case, you'll have to show what reputation you have in the market or in the country where you are considered as a celebrity or not. An ordinary man on the street will not be able to maintain an action against personality rights. The fundamental basis is that you must be popular.
Correct.
It is worth copying.
So Anushree, the courts have said that celebrity, so some of the celebrities, so they have given some loose definition by saying celebrity means the person about whom people talk or about whom people know. Like as loose as that too, celebrity means somebody who's so and so. So the courts have taken a lot of liberal view, but the main principle, as Veerendra has said, the main principle is you have to be a celebrity and not a self-proclaimed celebrity, like a true celebrity.
Right. Then there is one question. Would famous dialogues in the actor's voice or songs sung by actors amount to copyright or the personality right of voice under common law of the actor, or are they overlapping?
If they are part of the cinematograph film, the complaint can be made by the producer.
Right. So then there's a question.
His rights are violated.
Are memes an infringement of personality rights? Again, a very pressing question with the recent.
See, I feel, I'll tell you, I'll answer on memes. Memes, no, if you are not using the meme to commercially gain, then it will not amount to any kind of infringement, because parody is allowed. Parody is an exception to, say, copyright infringement also. Similarly, in case of a meme, what am I doing? I am not, see, personality right means the defendant is trying to take a commercial advantage by commercially exploiting a trait of your personality. Meme does nothing. A meme is only for people generally to laugh. It's like how stand-up comedy is. Person comes, he mimics. Similarly, memes are what? Memes, those, there are so many Lord of the Rings memes and all, which are made. But if the company or if somebody doesn't make it with the intention of making money out of it, then there is no problem.
They should be treated on the same level as a parody.
A parody, exactly. But to give you an example, that there was a case where there was a meme which said a Lannister always pays his debts. All right. For everything else, there is MasterCard. Now, that made by Anushree or Hiren will not amount to, because I'm doing it only for fun's sake, parody. But if MasterCards does it and advertises MasterCards by doing it, then there is a problem.
That's a good example.
So that reminds me of another question. So if there is a fair dealing usage, say for example, if I am using, say, a sound clipping or something for a review or criticism, do I still need to ensure that, the moral rights are protected? For example, should I still be giving credits of to the source from where I've taken the clippings? What is the interplay between moral rights and fair dealing provisions? Would they still apply? Veerendra sir.
The question is not very clear.
Even I was going to say, Anushree, I didn't understand the question.
So, for example, if I'm using a sound recording clipping for a fair dealing provision.
Yeah, you make a comment on that. That means you obviously acknowledge that the original is made by somebody else. And it is your criticism on that. So there is no question of there being any violation of the moral right.
There's a question: in a scenario where a name of a famous celebrity is used in one or more dialogues of a film, will the same infringe upon the personality right of that celebrity?
That depends on the facts, in what manner it is used and what purpose it is used.
Right.
Yeah.
If it's a passing reference, then it may not be. But if it is used for the purpose of commercial gain, then it will amount to violation of personality.
It is exactly, sir, like apna provision of section 52, incidental inclusion of work in cinematography is not an infringement. So a song playing in the background when there is a scene and a small railway station pe gana baj raha hai, that fellow can't come infringement of copyright because it is incidental, no? So same thing, if that it is only incidental, nothing, but as sir said, if commercial gain out of it, then probably.
Right. I think
I don't think you will be able to do justice. There are continuous comments which are coming.
Yeah, it's going more than 95 now.
All these, and later probably then we'll see and give some kind of a reply, because
you better give them the address of chamber of Mr. Hiren.
Definitely. Thank you so much, Veerendra sir. Thank you so much, Hiren, for such an educative and good session for all of us. And we'll definitely try to answer the questions for all our wonderful participants over here separately.
Thank you.
Thank you so much, Anushree. Thank you so much, sir. What a pleasure to be with you. As a to just be in the same frame, sir.
Thank you.
Thank you.
Thank you.
Thank you.